The webinar will begin in 2 minutes. The webinar will begin in 1 minute. Welcome everyone, and thanks for joining us for today's webinar, A Tragic Beneficiary Designation Case. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting material by email. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Lineberg, and Linus regularly speaks at industry events. His latest book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, which was written together with a CPA and a business broker, is now available for sale. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thanks very much, Jennifer, and welcome everyone. I'm glad you joined us today. Hopefully no one is too bleary-eyed after trying to chase down the results of the election last night. Before we get started on today's webinar, a tragic beneficiary designation case, let's decide what we're going to talk about next month in December. As most of you know, we have these seminars, and they are free seminars on the first Wednesday of the month. The December webinar will be on Wednesday, December 2nd at the same time, 11 a.m. Central. And you have three choices for what it is that we'll talk about. HSAs in a nutshell, year-end tax strategies for 2020, and the third choice is ethical issues with incapacitated clients. I'll ask Jennifer to go ahead and open up the poll and ask each of you to go ahead and vote in the poll and vote on what it is that you would like to hear about next month. Please go ahead and take a few seconds and do that right now. If you haven't voted yet, please go ahead and do so. I'll give you a couple seconds more. All right, let's go ahead and close the poll. Next month, we'll talk about year-end strategies for 2020. Thank you for voting and thank you for participating in these seminars. So let's go ahead and talk about this tragic beneficiary case. And I think it's important to set the stage first. We've heard us talk about the importance of getting the beneficiary designation right. If you've been on these webinars before, you've heard us talk about that idea. Now, why is that important? Well, for many of our clients, the beneficiary designation on their life insurance, on their non-qualified annuities, on their IRAs and qualified accounts, the beneficiary designation is going to control the transfer of more liquid wealth at death than any of the client's estate planning documents. Now, when I was in private practice, we would budget 4 or 5 hours total on talking to clients, getting a sense of what they wanted to have happen, and getting their estate planning documents right. Now, I doubt that many of you who are on the call who take life insurance applications or help clients with beneficiary designations on annuities or other financial assets spend even a substantial fraction of that time with them. And I'm not saying that you must, but that helps, I think, to give some perspective. A lot of the times when I was in private practice, I saw problems with beneficiary designations firsthand. And the types of problems ranged from the technical, somebody trying to allocate more than the money available between beneficiaries. That was one technical problem. Some of it was not quite getting the client's intentions right by writing down on the application process something that was a little bit flawed. And then, another problem that comes up is changed circumstances where the client or, the advisor don't take a look at the beneficiary designations to make sure that they're still right. So all of those things can certainly come up. And my strong recommendation to you, if you are on the call, is that you work with your clients to make sure that their beneficiary designations are correct. Now, how do you do that? Well, you got to find out what the beneficiary designations actually are. So you've got to get the source documents. And then you kind of go through a checklist of some of the things that might be wrong with the beneficiary designations. First of all, are the named beneficiaries consistent with the client's current distribution intentions? And figure A in getting it wrong is a client's ex-spouse is still the primary beneficiary of the life insurance policy. That's not always wrong, but it always needs to be thought about and perhaps fixed if the client has been through a divorce since the beneficiary designation was created. Are the beneficiary designations consistent with the client's other estate planning documents? If they're not, perhaps either the documents or the beneficiary designation needs to be updated. So part of our job as financial professionals is to make sure that our client stuff gets to the right people in the right way at the right time. And if beneficiary designations are wrong or estate planning documents are wrong, I think it's up to us to coach our clients about updating those. Is the client's estate either the primary or the contingent beneficiary of a life insurance policy or other financial product? If it is, to me, that's a flaw. And we're going to talk about that with the tragic case that we alluded to in the title of today's webinar. The main problem is if the client's estate is the beneficiary, it subjects the money to the probate process, and there are some definite downsides of that. The delay of probate, the fact that creditors have access to the funds potentially, the fact that probate is public where beneficiary designations are not, all of those are potential downsides to letting the estate be the beneficiary, either primary or contingent. Does the beneficiary designation make tax sense, right? This is up Jennifer's alley and my alley. If we've got a situation where we've got a third-party owner of a life insurance policy, for example, If there's a different third party that is the beneficiary, that could create a situation where there's a taxable gift at death or other taxable event at death. And we need to be intentional about whether our clients intend those types of results. And then I alluded to this in the beginning, is the beneficiary designation technically correct? One case from about 6 years ago hit the courts where the decedent tried to allocate 150% of a life insurance policy's death benefit among beneficiaries. And the case ended up in court, and the court was asked to sort out who was going to get how much, because the insurance company certainly wasn't going to be on the hook for sending out 150, an extra 50% over what the policy called for. So those things come up, and I think it's one of the reasons our clients should review their beneficiary designations with us, and we should take some care to help them change beneficiary designations where appropriate. So let's jump into this case. It doesn't really take that long. This is an Arizona case. This is estate of Gautier. And the question was, are the life insurance proceeds payable to a decedent's estate exempt from the claims of creditors? That was really kind of the deal. Most stuff that goes through probate, the decedent's creditors get a crack at, and that's one of the reasons not to name the estate the beneficiary. And in this case, the estate of Tobin. Tobin Gautier purchased a life insurance policy. He named his wife the primary beneficiary and his daughter the contingent beneficiary of that life insurance policy. Both the primary and contingent beneficiaries predeceased the insured, and the insured's estate ended up being in line for the money. And there were claims against the insured's estate that were filed during the probate process. And the personal representative of the decedent asked the court to rule that the decedent's creditors had no claim on the life insurance policies. The executor essentially argued that the policy was exempt from the claims of creditors. Now, when I present the case this way, it doesn't seem that tragic. Certainly, the fact that wife and daughter predeceased the insured, that is tragic in and of itself. But the case is much darker than that, and let's just talk about that part of it. Here's an excerpt from the local newspaper about what happened here. Please go ahead and read the screen. So you can see why we titled this a tragic beneficiary case. We've got the insured policy owner who allegedly kills his wife and daughter, and then shortly thereafter turns a gun on himself, allegedly, and that's why the named beneficiaries predeceased the insured in this case. That's apparently what happened here. So in any event, why did this case end up in court? Well, what happened is that the personal representative, the executor of Tobin Gautier's estate, was somebody on his side of the family. And the people who were the potential creditors were on his wife's side of the family. They were going to file a claim for wrongful death against the estate, and that claim was going to be part of what was argued about during the probate process. And so that's the deal. The estate, it's Tobin's side of the family trying to get the life insurance proceeds and keep the life insurance proceeds, and the claim against the estate is the late wife's side of the family. And so the court dispassionately looked at the language of Arizona law, and what it found was this. It says that if a policy of life insurance is payable to another person other than the person who is the insured or the person's legal representative, then the proceeds are protected against the claims of creditors against and the representatives of the estate are protected against the claims of creditors with regard to the insurance. So the court read this, and the court was asked to decide how to interpret this. If the estate is the beneficiary, is the life insurance protected or not? And so what the court decided and was affirmed in the appeals court, the named beneficiaries, if the life proceeds had been paid to named beneficiaries, they would have been protected. But based on the language of Arizona law, because the insured's estate was the beneficiary, the creditors, the insured, could collect from the life insurance proceeds through the probate process. And again, this case is based on the specific language of Arizona law. There are other states that have similar statutes, and here's just a sampling of some of those other statutes. We've got Alabama, where which has similar language to Arizona, and says that basically a named beneficiary is protected, but the estate is not. We've got the language in Colorado, which says when it's paid to a named beneficiary, it's protected. But if there's payment to the estate of the insured, it's not. Then we've got Florida, which says that if life insurance is paid to a named beneficiary, it's protected against claims against the decedent. But if it's paid to the estate, it's just like any other probate asset and is accessible to the insured's creditor. And for those of you geeks out there, we've got the citation to the statutes. And we've got the state of New York, which is not as clear about which is not quite as clear about whether an estate as beneficiary is protected or not. It is clear that if there's a third person beneficiary, it is protected, but it's unknown whether the estate would be considered to be a third person beneficiary or not. And then, for kind of a contrasting situation, the law where Jennifer and I reside here in Tennessee is a little bit different. And the law in Tennessee says that when the insured dies, any life insurance acquired by the insured or the insured spouse, which is payable to the insured's estate or to anybody else, shall be distributed without being subject to the debts of the decedent. So the protection here when the estate is the beneficiary in Tennessee is a little bit stronger than it is elsewhere. So you got to look to state law to figure out what might or might not apply. Having said that, to me it's almost always a mistake to have the estate be the beneficiary. Why in the world would you subject somebody to the probate process and the uncertainty about the money being accessible by the decedent's creditors if you have a choice? And so I think, at the end of the day, that's an important conclusion from this case. in this case, the estate was the proper beneficiary of the life policy because the first two beneficiaries had predeceased, and the decedent's creditors had access to the death benefit under Arizona law. And based on these tragic facts, it feels like the right result, doesn't it? That somehow the wife's side of the family should end up with most or all of the money based on their claim against the decedent for wrongful death. But this is, in a way, the exception that proves the rule. In more normal circumstances, our insured clients certainly do want to avoid giving creditors access to life policy death benefit after death. And so that's the lesson, I think, that we should take away from the case. This is the case that's the exception rather than the rule. Don't let the insured's estate be the beneficiary of a life insurance policies. And then as you're working with your insureds, be strategic about your use of primary, of contingent, and even tertiary beneficiary designations to avoid the estate being in line for the proceeds ought to be considered depending on the circumstances. And so to me, that's the takeaway from the estate of Tobin case. At this point, what I'd like to do is I'd like to thank you again for joining us today. I would invite you to subscribe to our YouTube channel, and I'll give it back to Jennifer to wrap us up. Jennifer?
Thanks, Linus, and thanks for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar to that email, asktheexpert@advancedunderwriting.com. And don't forget to join us for next month's webinar on December 2nd, Year-End Strategies for 2020. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. That's 615-224-1291. Thanks again, and best wishes for continued success.